Good afternoon. Hello, everybody. Hope you missed me. I missed you all, whoever you are. I see there's a whole bunch of people in here. Nice to see you all. Um, Obviously, my controls are a little bit off. So if I look a little bit bleached out, it's because that's the way it looks. I will try to correct this before the next live stream. But all you out there who are there, if you're there, like Jack and Frank and Toe and Barbara and Moody and Frank again and Lee and Zach and Akiron and whatever. And again, this reminds me of when I was a kid, there used to be a show for kids called Hobo Kelly. And at one point in time, she would talk to kids out in the audience like they actually existed. I think they were real names, but I don't think she was actually talking directly to them. So when I do that, it reminds me of Hobo Kelly. So thank you for bringing those great childhood memories back to me. I appreciate it. So what I'm going to do is bring you kind of up to speed what's going on as of today, as far as I know, and then we'll go. That will be it. And I'll let you have a wonderful Valentine's Day. Enjoy your President's Day, and maybe you can provide some. I'm going to ask you for some assistance, so maybe you can help in that regard. So to everybody out there, hello, I miss you. I'd love to see you all. So maybe you could meet me someday. Meet with me so we could all get together. That would be a great thing. So it's just some questions I have before we start. Did Noah include termites on the ark? And if not, why not? What happens to a frog's car when it breaks down? It gets towed away. What do you call a sleeping dinosaur? A dinosaur. Dogs hate driving. Do you know why dogs hate driving? Because they can never find a barking space. And last but not least, and this is the one that I still haven't figured out the answer to. I struggle with it in my life also. It's really difficult, to be honest. But at what age is it appropriate to tell your dog that it's adopted? I've been wondering about that for a long time. Anyway, and I'm sure you guys missed all those wonderful jokes, so I'm glad I could bring them back to you and bring you online. So I'm going to talk about three quick things. Talk about what's going on in the near term with the litigation and GTII. Then I'll talk about a filing that was done by Candice Carleone. Hope that's the correct pronunciation of her last name. I hope so. I'm going to refer to her as Candice so I don't butcher the last name. And then I'll talk about a filing that I did. And we'll do it in that order. So first of all, discovery, what's going on with the case. So on the 19th, the motion to approve the settlement with Griffin was approved. There was no opposition to it. So that's going forward. There's a hearing on the 19th of February, and within that hearing, there's a status conference about an update as to the audit. So I will keep you apprised of that. I guess that would be, today's the 13th, Friday the 13th, lucky for us all. That would be next Thursday, I believe, would be that hearing, and I will try to participate and find out what's going on. And I'll keep you apprised of that, of course. And then separate and apart from that is there's ongoing discovery or depositions and the like, other means by which you can do discovery. Anyway, that's going on. I believe the deposition of the attorney Brooke is on March 3rd. I think that at least it's scheduled for that. I know there's depositions scheduled also, or at least I saw a request for subpoenas going out to Alpine. You know Alpine. And so this is going to be kind of the interesting part. This is where I'm going to ask for your assistance and perhaps to help counsel who will be deposing those witnesses ask better questions. So Alpine will be one deponent. And, this might be for purposes beyond just this, because we won't have the opportunity very many times to do these depositions. So one is for Alpine, and whether they're who they produce, who that is, and whether they know anything is a different story. But let's pretend that they do. The other one is going to be for the DTCC. And I think this is with regard to that concentrated short position that the receiver seems to be following up on, or that seems to me to be, the way I look at it, that's a bone that the receiver is trying to throw to shareholders to show that he's exhausted this issue. That's the way I see it. Is it, do they expect to find an answer? I don't know, but I think they're trying to show that they've used diligence in trying to explore the issue. That's why I believe they're deposing Alpine and DTCC. So with regard to those, and because the counsel for the receiver wasn't as intimately involved on the short side, and that wouldn't be the focus of their examination, all you guys out there, what I'd like you to do, and it would be collectively, so find somebody to be in charge. And I have to preface this by saying that the Receivers Council may not end up using any of this stuff, but amongst yourselves, with somebody who ends up in charge who then could forward me the collective version, is put together a list of questions. Now, this is not trying to I got you questions. This is questions designed to elicit information that you think is really important. It can't be long questions. They have to be short, and it's helpful if you don't allow a lot of room to answer, if you're very specific in the call of the question. And so the two entities I just referred to, one is Alpine, one's DTCC. So I'm talking about both. So perhaps collectively, and when I put this on YouTube, you guys too can participate, but perhaps you can put together a list of questions that you'd like to have answered, again, that are not got me questions, that are not too long, that are very directed to a specific issue and specific question, and put them together. Then somebody will send me that collective list. I will then go through them and see kind of what I think are appropriate or inappropriate, and then I would provide them to the receiver. And since I will be attending those depositions too, then perhaps some of those questions can get asked. No, not guaranteeing it, but I think it's an idea. And again, because as to the shorting side of this, we come at this at a different way than the Receivers Council would. And that's not meant as a critique. I'm just saying that's the reality of it, because we're all shareholders and we've been watching what's going on. And the Receivers Council is just, doing their work here. But because of that, I think it'd be a good idea if we can kind of direct the Receivers Council and maybe get some insightful answers that might help beyond this. But so I'm suggesting get together amongst yourselves. Somebody decide to be in charge. Somebody take the reins and provide that. And if you do, I will certainly look at it and present to the Receivers Council stuff that I think is appropriate and can be asked. Whether the Receivers Council asks, I don't know. Okay, so I've done that. I've said that. That's upcoming. That's kind of on a different side of this dispute, because this is on the short side of this dispute. So March 19th, there's a hearing regarding the receiver's compensation. I did a live stream about it. I said I was going to file a brief, and I will get to the brief that I filed. And I try to keep my, because of the name brief, I try to keep my briefs brief, which I did. So separate and apart from that, the counsel who represents some of the shareholders, and I mentioned her name before, I'm going to refer to as Candace. They filed a brief also, and their brief relates to that motion hearing on March 19th also. Their brief was filed on February 6th. My brief was filed on February 4th, just to give you an order of the events. And I'm summarizing, very greatly summarizing. In essence, what their brief says is we don't dispute the money part of the receiver's request. In other words, receiver's asking for like $8,000 based upon 10% of money that he just recaptured, maybe 85,000 or something like that. Those are all approximate numbers. But as to the shares, they have two concerns. One, the magnitude of the fee might interfere with the ability to close other deals, and that could create a conflict of interest between the interest of the receiver and the interest of shareholders. And second in the part, besides the fact that might interfere with potential deals, one of the other reasons why the deal has been held up is because of continuing delay in getting the audit report. And so they are asking the court to condition the award of fees and shares, so not the fees, because the fees are not being contested, but to condition the award of shares upon the delivery of the audit report. So when they're saying you can't issue, or the Candace's side, which is our side also, says that they are asking that the court not give out the shares until the audit is done, and that all awards of stock, so that's one condition, and that all awards of stock shall be interim and subject to final review, subject to conversion to cash, and not tradable not tradable except with court approval upon notice. So somewhat kind of the same issues that you'll see I brought up and discussed in my last live stream, but basically they're saying we need the audit. If the award is the award, it's not a final award. It's still subject to court approval. It's also subject to conversion to cash, which I think is an important item. For example, because in the last in the motion requesting compensation that we're talking about here, they valued their shares, that 5 million shares, at like $60,000, 1 cent, whatever. So if it's convertible to cash, then I'm less concerned about if they get 15 million shares. Again, I think I mentioned that in the last live stream. It'd be like 150 grand. Take it, whatever. I think that would be fine. Nobody's going to bitch about that. But they're basically saying, get us the audit report. This is not final. It's subject to conversion to cash and needs to be subject to court approval to be traded. So that's the approach. And one of the things they raise in their papers and I'm reading from their brief that they filed. However, the scope of the receiver's equity ownership in GTI has apparently created an impediment to consummating the transaction favored by shareholders and previously advocated by the receiver. This has created a situation where the receiver's ownership, control, and potential sale of the GTI shares creates a potential, if not actual, and I think it meant to say conflict with the AIversity transaction. It doesn't exactly say that, but that's what's intended there, I believe. So they're basically saying is that the receiver's equity position has changed. So now they have too big a stake, and it creates a potential conflict between what the interests of the receiver might be and the interest of consummating a transaction. That's basically what it said. That's my interpretation of what it said. And the conclusion and what they're asking for at the end, for the reasons stated above, GTI shareholders respectfully request that any award be conditioned upon the completion of the audit report, and that all awards of the stock to the receiver be interim and subject to final review, subject to conversion to cash, and not tradable except upon court approval upon notice and for such other relief, etc. And I'm perfectly fine with those conditions, especially if they're and. So it has to be, it's subject to final review and subject to conversion to cash and not subject to trade without court approval upon notice. I'm okay with all those conditions, and they would satisfy me per se. and my requests. So a couple days before that, I filed a short, I called it a declaration in opposition of GTII shareholder, me, in opposition to the receiver's motion for compensation. And I'm just going to read it. It's just 3 or 4 pages. And I'm going to read the pertinent stuff. And I'm just jumping in now. In my opinion, the receiver in particular, through the highly compensated Receivers Litigation Counsel, and by that, stop right there. I don't mean that in a negative way. I just mean that they've been highly compensated. I don't mean they've been overcompensated. I just mean they've been highly compensated. The highly compensated Receivers Litigation Counsel, and likely with the assistance of its forensic accountant, has done a good job in many respects. So it's not just the highly compensated Receivers Counsel, but it's also the forensic accountant, I believe, because I think that it's been referenced before, that the receiver knows and hired. To the extent the parties have been forced to abandon or return shares, I attribute that primarily to the actions of defendants' litigation counsel. I have observed them in deposition and understand the results. So I'm going to stop there. So in my opinion, the reason that things have moved forward is not because of, and this is just my opinion, and I'm not saying this is black and white. I'm sure the receiver has had input in this, but I think primarily and certainly the overwhelming push has been through the defendant's litigation counsel, and I've seen it in person, been at deposition, seen the hearings, etc. So that's the way I see it. And in addition, the tracking things down, probably the forensic accountant probably did a lot of that work, is my guess. I don't know, because I don't think in the reports that's been delineated sufficiently. I'm going on now. I was informed that as of early November 2025, that the receiver's primary counsel had been paid as of that time approximately $500,000 excluding costs. So stopping. So as of the beginning of November, the receiver's litigation counsel had been paid over $500,000. That doesn't mean they hadn't billed more than that, but that's how much they had been paid. I'm not saying, by the way, that's excessive, because I think they've done a lot of work, and I think they're the kind of my pitch here is that they've been the primary moving force in getting this done, not the receiver per se, in my opinion. And again, that's based upon what we know, based upon the reports that have not kind of addressed these issues at all. There apparently is also a cost of corporate counsel, I believe in Texas, and during the last status conference, Mr. Siciliano indicated that separate counsel were reviewing the AI deal terms. Hence, legal fees alone, which have generated the primary response from defendants, may be approaching $1 million by the end of the first quarter of 2026. Moreover, it appears to me, who attended nearly all of the depositions, that it is paid counsel, not the receiver who is responsible for any gains herein. It appears that the receiver is trying to get compensated for the work of compensated agents. And again, that's just what it appears to me. And I'm not putting out malice. I'm just saying, in the end, that's what kind of makes this compensation package unreasonable. And that's in addition to, as what was said in Candace's papers, that because of the percentage of ownership by the receiver, it puts his interests certainly more than potentially in conflict with those of the shareholders, unless there's modifications done to that compensation agreement. So I'm not trying to be disparaging. I'm just trying to say the value provided here, based upon my examination and participation, is mostly in the hands of counsel and probably a forensic accountant, and maybe the auditors. I don't know what specifically the receiver has done. So generally, in most receiverships, the receiver would be, or a lot of times, the receiver would bill for his time. So if he did with tasks, he would charge a fee and bill for his time. A lot of times, just as in this case, the receiver also as counsel. And a lot of times the receiver is a lawyer and the receiver hires counsel. So the receiver gets paid and the lawyer gets paid. But in this case, because of the way this is set up, we don't know what tasks the receiver is doing, and we don't know the amount of time, and we don't know if it's reasonable in light of what we're paying for other services. I don't mean that's malicious or whatever. I just think it's the way it's set up. It created an unreasonable situation and also created a potential conflict also. Moving on, paragraph 4. Additionally, apparently the receiver not only has hired an auditor, but also has a forensic specialist on board. It is likely that this will also cost several hundreds of thousands of dollars, yet nearly 18 months after being engaged with the promise to immediately undertake corrective action, no audit has been completed. It is likely that this forensic accountant, rather than the receiver, is the one who made material discoveries. If the receiver was only being compensated for his time and being compensated for his time and efforts, then reasonableness of his compensation would not be an issue. Since he is not being compensated for his time, and we do not know what he is being compensated for at all, this brings reasonableness into issue. So I think that's self-explanatory, kind of goes upon what I said. Maybe it's not self-explanatory, but I'm basically saying under this, the way it's set up, since we're not paying for time, we really don't know what he's being compensated for. So 5. So excluding the work of his various counsel, his auditors, his forensic accountant, what has the receiver done to deserve receiving 10% of GTII? This was a typical receivership. The receiver would bill for his time, and we could see the validity and success of the actions of the receiver. Because that was not the route that the plaintiff's counsel and receiver chose to take, it is really not possible to conclude that the receiver's fee is reasonable. Again, it appears most of the value seemingly inuring to the benefit of shareholders has arisen out of the actions of litigation counsel who is also handsomely compensated. And I don't mean that in a negative way. I just mean that's the reality. Paragraph 6, the reasonableness issue is probably one of the reasons that receivers generally do not get compensated on a contingency fee basis. It establishes a situation where, like the instant, the total compensation paid to the receiver is excessive and therefore not reasonable. Paragraph 7. I think we're almost on the, this is the last one. Based on what the receiver's counsel has indicated in his most recent reports, the receiver, through its counsel, may be able to cancel as much as 150 million of the 300 million or so outstanding shares. According to the current agreement, the receiver would obtain 15 million of the 150 million shares, and from his position as receiver, he would be the single largest shareholder, owning 10% of GTII. Garnering a 10% ownership interest appears to be a patently unreasonable fee, even ignoring the fact that the majority of the efforts deriving any success were undertaken by highly paid agents, such as counsel and the forensic accountant. His stock ownership is on top of the cash that he has already received, which I do not object to. 8. In its motion, the receiver has characterized the value of the shares, 5 million plus, as being worth approximately 1 penny each. If that is true, I would suggest that instead of ownership of 10% of the company's stock, that the receiver be paid in cash at 1 cent per share. 9. There are further facts that make the fee request unreasonable. There are no current restrictions as to when the receiver may sell his stock. Per his existing pay package, he could obtain more than 15 million shares of a reduced float GTII stock, making him the largest shareholder. First, that could unfairly and completely dilute the interests of real shareholders. Moreover, with no restrictions on what he could sell his shares, the receiver would be in the position to sell his shares before other non-insider shareholders could. Moreover, by selling huge blocks of shares, that would further depress the price that normal shareholders could get on their future stock sales. This all seems unfair and one-sided. Paragraph 10, and we're home. The receiver's compensation is unreasonable because there are no restrictions and waiting periods for when the receiver can liquidate the millions of shares of stock he received. It would appear to be patently unfair if the receiver could sell his shares before other shareholders. And then I declare the penalty of perjury. So I filed that a couple days before Candace filed hers. We kind of address a lot of the same issues. This will be, and I assume there'll be a response, and I would expect a response to probably try to justify the receiver's compensation about all they've done, all he's done, how about all the, has to be a fine line because if you're one of the agents getting paid big money, you can't say you've done nothing. But they're going to have to, I would expect them to try to upplay what the receiver has done. But overall, the bottom line, I think the basic problem is that the receiver's compensation is not reasonable. And without adjustment, I don't think that changes the equation. And I think we need to act as such. And that has nothing to do with regard to the performance of the receiver. That has to do with what the form and amount of compensation. And again, in most cases, it wouldn't be on a contingency. And now you can see why a contingency fee setup where the receiver is getting a percentage of what he brings in creates a potential issue. If it was just money, probably not. But here we're talking about ownership of a company and versus shareholders. That seems to be directly at odds. So I'm going to leave you there. Just quickly summarizing, there was a opposition and a reservation of rights filed by Candace on behalf of a bunch of shareholders as to the compensation issue. Before that, I filed a declaration in opposition to the compensation request of the receiver. That's going to be heard on March 19th. We have different objections. Candace's objection relates to the audit not being done, potential conflict, etc. Mine focused on the reasonableness of the compensation, what others were doing, etc., along with the amount, and some of the same issues are crossed over. And on the 19th, there will be a hearing that the only subject matter that I think we'll be interested in will be the audit that might be discussed on February 19th. There's a bunch of depositions set on, starting one on, I think, March 3rd for one of the attorneys, but there's also depositions left for DTCC and Alpine, and I asked somebody to take over the part about collecting. If you guys have questions you want to ask Alpine or DTCC, one of you could collect them, forward them to me. I would see which ones were appropriate, then I would forward them to Receivers Council. So deposition, if they chose, they could ask some of these questions that perhaps you guys have been waiting to ask for all this time. That's kind of a quick summary along with some great jokes. I wish you all happy Valentine's Day and a happy President's Day. Have a great weekend. Enjoy your weekend. That's kind of what we're talking about here, right? And we'll see you soon. We'll see you very soon.